Yes, Mr. Young. You will see that Lady Justice Simler is attending remotely. Before you start, this is not my normal court, and the chair is particularly low. We'll see if there's somewhere where I can adjust it. Much better. Very intelligent. Thank you. Yes, Mr. Young, off you go.
My lord, my ladies, may it please the court. I appear for the appellant, along with Miss Detmarsh and my learned friends, Mr. Siddle, Queen's Counsel, and Mr. Anderson, represent the respondent, and Mr. Laing, Queen's Counsel, and Mr. Smith, represent the intervener. Can I confirm that your ladyships and your lordship have received the core and supplementary bundles and the authorities bundle?
We have.
I'm grateful. And that there was also an email from the intervener yesterday sending a slightly tweaked version of their proposed structured approach to the separability question. I'm not sure whether
now,
that has
this may just be my failing. I'm not conscious of having received that.
No,
nor is Lady Justice Elisabeth Laing. I'm not sure about Lady Justice Simler.
I did receive it. I received it as an email yesterday afternoon.
Well, I don't know what the two of us managed to do with it, but when you get there, Mr. Laddie, why not hand it up?
We'll hand up at that point.
Yes. Thank you.
Thank you very much, my lord. In terms of time estimate, I'm not sure whether there are any constraints on the court's time today.
Well, there are no. I've got two things to say about time. No, there are no constraints, but we will have to rise promptly at very shortly before 4:30 is the absolute limit. When my clerk said that we were concerned the timetable was a bit tight, that reflected my reading at that stage, which was superficial, and I had not fully appreciated that the attribution point was not live. Given the issues as I now understand them to be, all three of us are confident that this case ought to be finished today. So although I'm not positively withdrawing the possibility of going into tomorrow if there's some serious problem, we hope and expect that we will finish today.
Well, I'm very grateful for the indication, and for my part, I would certainly hope to get through my submissions in no more than 2 hours at most. So.
Well, that would be terrific.
My ladies, my lord, this is an appeal against the Employment Appeal Tribunal's order sealed on the 7th of October 2021, dismissing the claimant's appeal against the Employment Tribunal's decision sent to the parties on the 2nd of March 2020, which in turn dismissed her claim for automatic unfair dismissal pursuant to Section 103A of the Employment Rights Act. There are 2 grounds of appeal. Both of them relate to the question of separability, or to be more precise, the extent to which conduct by an employee in making protected disclosures can properly be separated from the protected disclosures themselves, and hence amount to a legitimate reason for dismissal. My lords, before I go any further, I've just been passed a note which indicates that the appellant herself, who I think is supposed to be joining via CVP, doesn't appear to be joined to the CVP. I'm not sure whether that is something that it's possible to look into.
Yes, annoyingly, the court official who was seeing the CVP was working has just left the court.
I can see her name in the list of attendees. She's there listed.
I'm grateful, my lady. I wonder if.
Well, look, I'm afraid it wouldn't be. I'm obviously anxious she should be able to watch it. I don't think it would be appropriate for us to have a delay in order for that to happen. But I wonder, could you get in touch with Alam and ask him? You understand what the issue is, do you? It's Ms. Corin, the claimant, who was attending by CBP. There's a question mark whether she's available, or so whether she's accessing it. Thank you very much indeed.
I'm very grateful,
right.
And I apologise for the delay. And I'm aware, of course, that she would have access to the live stream in any event as a fail-safe.
well,
no, actually, I think
for
that's
the
all
reasons
right.
you gave, and the original reason why we set up the CVP was that there were some difficulties about
Sorry,
that.
my lord. Yes, that is correct. I'm misremembering that. I do apologise. So the structure of my submissions will be as follows. I would like to start very briefly by looking at the Employment Tribunal judgment, picking out key findings that I will then come back to in relation to the grounds of appeal, and in relation to which the claimant puts a slightly different emphasis to the respondent's emphasis in its skeleton argument. And then to deal with the two grounds in turn. Firstly, the first ground, that the Employment Tribunal erred and the Appeal Tribunal erred by endorsing in finding inconsistent findings of fact in relation to the question of separability as between the detriment claim and the dismissal claim. And then the second ground, which is the more general ground, that both tribunals below erred in their approach to the question of separability and all came to a conclusion that was unsustainable. So if I could start by taking the court to the Employment Tribunal's judgment, which is at tab 20 of the core bundle. It starts at page 243, but the particular part that I'd like to start with is paragraph 53, and in particular page 261, where the tribunal makes findings about protected disclosure 3 and 4.
Yes.
So paragraph 53E.
Just one moment. All right, thank you very much. I don't know the source of your information, but it's been confirmed that Mr. Cron is on the link and can hear what's happening. So I don't know why people thought he wasn't.
I'm very grateful. Thank you very much, my lord. So, paragraph 53E is the tribunal's finding in relation to protected disclosure 3, and this was the email on the 26th of September 2018. And in particular, halfway down that paragraph, the tribunal referred to the MRPA concern, which is part of protected disclosure 3, and summarised it as being that the industry standard, the claimant considered that the industry standard MRPA template was designed for bank-to-bank lending and not for use with non-bank institutions. The tribunal then went on to find in subparagraph F that that protected disclosure 4 was that at a meeting between the claimant and Jenny Harding, who was the head of legal on the 22nd of October, the claimant reiterated concerns regarding the MRPA agreement, particularly the bank-to-bank issue. He said, i.e. the same issue as PD3. That then leads on to the incident between the appellant and Ms. Harding on the 22nd of October. The tribunal's findings about that are in paragraph 141 of the judgment, which is at page 279 of the core bundle.
Yep.
And so, the end of that paragraph, the tribunal found that the claimant raised the MRPA concern with Ms. Harding at that meeting on the 22nd, and that she questioned her legal awareness about the matter that constituted her PD4. The other key feature of the incident with Ms. Harding was the email that the claimant sent to her on the following day, the 23rd of October, and that is described and set out, in fact, by the tribunal at paragraph 155 of the judgment on page 281. And after some introductory remarks in which the tribunal concluded that the email was conciliatory in tone, careful in the way that it explained why the claimant felt it important to raise the bank-to-bank issue personally with Ms. Harding, the tribunal then set out that email, and in particular I would draw your ladyship's and your lordship's attention to the part in the second paragraph where the claimant wrote, "Therefore, I was a bit uncomfortable when the legal team questioned why it's bank-to-bank, since it's a reflection of legal awareness. And then if I'd raised this bank-to-bank issue in the audit report, the reader might have raised a question on the professional awareness, brackets, not integrity." The claimant, the appellant, brought a claim for detriment pursuant to section 47B of the Employment Rights Act in relation to, amongst other things, her treatment by Miss Harding in this incident. And the tribunal set out what that detriment claim was, and set out what the detriments were said to be in a number of places. The most convenient may be to go to paragraph 211, which is page 296 of the core bundle. And for present purposes, the significant one is detriment A, the treatment of the claimant by Miss Harding on the 22nd to 23rd of October 2018. And the tribunal set out in more detail what the elements of that first detriment were in paragraph 215A, which is over the page on page 297. And in essence, it had three parts to it. Firstly, Miss Harding going to the appellant's office without making an appointment in an agitated state. Secondly, becoming more agitated when the claimant made her PD4 and questioned her awareness of a lack of awareness of PD4. And then thirdly, that Miss Harding told a number of people in the office about the incident, including Miss Yates, Miss Garrett Cox, Mr. Henderson and Mr. Maskell, wrongly said that the claimant questioned her professional integrity. It is of note, in my submission, that at least some of that detriment occurred after the claimant's email on the 23rd of October. And I can show that by taking the court to paragraphs 159 and 161 of the judgment, which are on page 283 of the court bundle.
So which page?
So page 283, my lord.
Did you say 283?
Yes, 283 of the court bundle, and it's paragraph 159.
Yes.
So here the tribunal is carrying on the chronology after the claimant's email on the 23rd of October, and it noted in paragraph 159 that Miss Harding forwarded the email chain to Miss Yates, and then in paragraph 161 it refers to the further steps that Miss Harding took in relation to this, had a conversation with Miss Yates, then Miss Yates explored the possibility of mediation, but Miss Harding didn't consider it would be helpful. She also spoke to Miss Garrett Cox. So those, in my submission, are elements of the detriment on which the claimant was relying in relation to the incident with Miss Harding. And I'll explain in due course why that's particularly significant. But the tribunal then had to go on to consider Miss Harding's explanation for the conduct, for her conduct, that was subsequently, or that was said to be a detriment. And her explanation for that was set out in paragraph 142, which is at page 279 of the Bible. So Miss Harding said that 3 or 4 times during the conversation on the 22nd of October, the claimant had said that Miss Harding should not be in the role of head of legal if she was asking questions like that, and that the appellant would escalate her concerns to the CEO. But the tribunal rejected that evidence from Miss Harding. And in paragraph 144, just over the page, the tribunal made the finding at the end of that paragraph that, at least in relation to the 22nd of October, what upset Miss Harding and led to her walking out was what the claimant said about her PD4 and her legal awareness of that issue. And there is further evidence in my submission of the reason that Miss Harding relied on to explain her detrimental treatment in a couple of paragraphs of the judgment that quote from further emails from her. One is paragraph 154 on page 281. So this is an email that Miss Harding sent to the claimant on the 23rd of October, but before the claimant's significant email on the 23rd of October. And she said that she needed more time to think about things because, to be honest, you have really upset me by calling into question my professional integrity in the way you did yesterday. Subsequent to that, the claimant then sent her the key email on the 23rd of October, and then subsequent to that, in paragraph 158, on page 283, Ms. Harding replied to the claimant's email, and she disputed that she'd walked out with anger. She said, "I was upset. You were in effect questioning my ability to do my job, and you have done so again in your email below." In order for the claimant to prove her detriment claim, she had to prove that the protected disclosures had a material influence on Ms. Harding's treatment of her on the 22nd and 23rd, and the tribunal dealt with this question at paragraph 215 of the judgment, which I took your ladyship's and your lordship to earlier. It's page 297 of the judgment. The conclusion is stated at the start of that paragraph. We find that Ms. Harding's treatment of the claimant on the 22nd and 23rd was materially influenced by the protected disclosures, but it's set out why, and although there are more subparagraphs than this, essentially they can be grouped into three reasons. The first reason is contained in paragraphs A to C, 215 A to C, and in essence is that the fact that Ms. Harding had subjected the appellant as a whistleblower to a detriment raised a prima facie case that it was because of the protected disclosures, and the tribunal had rejected Ms. Harding's explanation for her conduct. The second
Hang on a
reason,
second, sorry. How are you characterising those first three?
so, my lord, I'm characterising those first three as saying that the facts surrounding the detriment, i.e. the fact that Ms. Harding had subjected someone who had made protected disclosures to a detriment, themselves raised the prima facie case.
Yep.
And because the tribunal had rejected Ms. Harding's explanation for it, that was a reason why the detriment claim would succeed, on its merits at least, leaving aside limitation. So that's the first reason. The second reason is in paragraphs D and F, and that reason was essentially that the protected disclosures themselves directly influenced Ms. Harding's actions because she disagreed with protected disclosure 3, and it made her uncomfortable. But the third reason, which is in paragraph 215E, and which was in addition to the first two reasons and separate to them, was that the professional awareness point that the claimant raised was, we find, inseparable in this case from the protected disclosure itself. And therefore, essentially what that means is that the reason given by Ms. Harding was not properly separable from the disclosures themselves, and therefore, even absent the other two reasons for finding the detriment claim proved on its merits, this non-separability point would have been sufficient for the detriment claim to succeed. Of course, it didn't succeed because of limitation, but nonetheless, in my submission, those findings are very relevant to the dismissal claim. Moving on then to the dismissal claim, the tribunal's key finding about the reason for dismissal is, of course, paragraph 226, which is at page 301 of the core bundle, and in which the tribunal said that we accordingly find the respondent's principal reason for dismissal in this case was the claimant had questioned Ms. Harding's professional awareness/integrity, both orally in the meeting on the 22nd and in the subsequent email on the 23rd. That was a matter of conduct on the part of the claimant. So that's the final conclusion on the automatic unfair dismissal claim. But just to go back very briefly to the building blocks for that conclusion, the tribunal first of all concluded that the two decision makers were Ms. Garrett Cox and Mr. Mohammed, and for your lordship and your ladyship's reference, that's paragraph 223 of the Employment Tribunal's judgment. And looking at those two decision makers, paragraph 169 of the judgment on page 286, the tribunal looked at Mr. Mohammed's reasoning. And the tribunal found that the dominant factor in his agreement to dismissal was that he considered the email to Ms. Harding to be unjustifiable and career limiting. There's a bit more detail in relation to what he found objectionable about it in paragraph 160, That's page 285 of the core bundle. The tribunal there described that Mr. Mohammed telephoned the appellant after he was blind copied into the email, and he said that the email was totally unacceptable. Contrary to everything he thought he had told the claimant previously about not allowing interactions to become personal, it called Ms. Harding's competence into question, suggesting twice that she lacked legal or professional awareness. So those were Mr. Mohammed's reasons. I acknowledge that what's referred to by the tribunal as the Canepa incident, which was an earlier incident in which the appellant had approached someone as they were clearing their desk to ask them a question about an earlier audit. That was a factor in Mr. Mohammed's thinking, but it was not the principal reason for dismissal, as can be seen in paragraph 226. Ms. Garrett Cox.
Where is that to be seen, sorry?
That
Para
is
169. Last
Yes.
two
End
sentences.
of 169.
Last two sentences of 169.
Thank you very much, my lady. The end of 169.
Yes, I mean, but let me just.
Well, my lord, I refer to paragraph 226, which is the tribunal's ultimate conclusion.
No, well, quite. That's what I just wanted to check, because it could be said, depending how you chose to do it, that the reason was the way in which she interacted with employees on several occasions, of which the most important was the most recent.
Yes.
But the Canepa one was one. Then that would be a single principal reason
Yes.
with two
Well,
elements.
Well, my lord, what I say about that is that if one reads paragraph 226, the tribunal make quite clear that it's more specific than that.
Yes, no, I see that. Thank
It's the claimant's conduct on the 22nd and the 23rd. And in terms of Ms. Garrett Cox, just very briefly, the tribunal in paragraph 175, page 286 of the core bundle, described the dismissal meeting that Ms. Garrett Cox chaired, and describes her raising the incident with Ms. Harding as the first incident that was mentioned. I acknowledge she did go on to mention other things, but that was the first thing that was raised.
So sorry, I was just making my note. Where are we on
I'm
for
sorry,
Garrett
it's
Cox?
paragraph 175.
175, yeah, thank you.
But that's the description of the meeting, and that is, of course, followed up in the dismissal letter itself on paragraph 178. Over the page, in which Ms. Garrett Cox wrote in the second paragraph that, as discussed at our meeting on the 22nd of October, your conversation with the head of legal in connection with the trade finance audit led to her strong view that you were questioning her professional integrity, followed with a subsequent email. It says on the same day, but I think that's actually wrong. It was on the subsequent day, reinforcing this view. So those are the building blocks of the conclusion, but the conclusion is as set out in paragraph 226. I should just finally mention one further point, or in fact very briefly two further points in relation to the reason for dismissal. The first is paragraph 230 of the Employment Tribunal's judgment on page 302. And this is one of the points that the tribunal said that it should deal with for completeness. Paragraph 230 was the tribunal dealing with the respondent's pleaded case that the reason for dismissal was either conduct or some other substantial reason in terms of breakdown of the claimant's relationship with key stakeholders. The tribunal found that was not the reason for dismissal, both because it was not advanced by the respondent as the principal reason for dismissal, but also because it found at the end of that paragraph that it was simply not true for the reasons the tribunal had dealt with earlier, and which I will come back to. The final point that I should deal with just about the tribunal's judgment and the dismissal claim is paragraph 225 of the judgment on page 301. And the tribunal there considered the issue of whether it made a difference that Ms. Harding characterised the claimant's conduct as calling into question her integrity rather than her professional awareness. And the tribunal concluded that it didn't make a difference because Mr. Mohammed was aware of the distinction and was aware that the claimant, that the appellant was not in fact questioning Ms. Harding's integrity, but rather her awareness. And then secondly, because as far as Ms. Garrett Cox was concerned, it wouldn't actually have made any difference to them, whether it was characterised as questioning her integrity or questioning her professional awareness, and therefore for those reasons it didn't make any difference. So the allegation that the claimant had questioned Ms. Harding's integrity made no difference and or was not an operative reason for dismissal. So that's a very brief run through of what I say are the key findings
that's extremely helpful.
made by the tribunal. And I'll move on now, if I may, to the grounds of appeal.
Sorry, Mr. Young, before you do, should you not also refer to 229?
Well, my lady, I'm grateful. The 229 is the tribunal's finding that the decision makers were not motivated by the protected disclosures when taking the decision to dismiss, and the basis for that was that none of them looked at the underlying content of the disclosures, but in my submission, that finding is inextricably bound up with the finding that the claimant's conduct was separable from the protected disclosures, because that finding, i.e. that Mr. Mohammed and Mr. Garrett Cox were not influenced by the disclosures, is only sustainable if the claimant's conduct is properly separable from the disclosures. And for reasons I'll go on to deal with in relation to the grounds of appeal, I say that it was not properly separable. So the first ground of appeal is that the Employment Tribunal's implicit conclusion in paragraph 226 that the claimant's conduct was separable from the fact that she'd made protected disclosures in relation to the dismissal claim is inconsistent with its finding in paragraph 215E that the conduct was inseparable from the protected disclosures in relation to the detriment claim, and therefore it was not a finding that was open to the tribunal and was an error of law. Now, I can summarise this first ground of appeal very shortly. As I have shown, the tribunal had found in paragraph 215E that the professional awareness point that the claimant raised was inseparable from the protected disclosures itself. And yet, in paragraph 226, the Employment Tribunal went on to find, in the context of the dismissal claim, that the claimant's conduct in, and I quote from paragraph 226, having questioned Ms. Harding's professional awareness / integrity, both orally at the meeting on the 22nd and in the subsequent email on the 23rd, was in fact separable from the making of the protected disclosures.
But this isn't a sort of metaphysical point about separability. It's a point about the motivation of the person in question. And the person in question here is Ms. Harding, as far as the detriment is concerned, and Mr. Mohammed and Ms. Garrett Young as far as the dismissal is concerned. There's no reason in principle why you can't find that they were inseparable in the one case. Perhaps inseparable is perhaps putting it the wrong way. Were separate in the one case, or not separate in the one case, and separate in the other. If I'm right about that, the finding in relation to Ms. Harding's motivation doesn't necessarily carry over into the motivation of Mr. Mohammed and Ms. Garrett Young. Isn't that right?
Well, my lord, I'm grateful because you've anticipated the 2 points I was going to come on to.
Sorry.
In terms of elaborating the proposition that is inconsistent. And just to tell your lordship where I'm going,
yes.
I would propose to develop the submission that they are inconsistent in 3 ways. Firstly, by submitting that the conduct in question, i.e. the claimant's conduct that was relied upon by the respondent as being the reason for the detriment and the dismissal, was the same or materially the same in both cases. Secondly, and this is the part that deals particularly with your lordship's point, that the test of separability is objective, and therefore, provided the conduct is the same, it doesn't make a difference that the decision makers are different. And then, thirdly, I was going to come on to deal with the respondent's point that in relation to the test for causation, it's not technically a test for causation, but the extent of the influence protected disclosures have to have, and to make the submission that it doesn't make a difference that that's different between the detriment and dismissal. But
Sorry, I haven't quite got the third point.
So the third point is that the respondent says the test for whether protected disclosures were the reason for a detriment is that the protected disclosures have to have a material influence, whereas the test for the dismissal is that it has to be the sole or principal reason. And the respondent suggests or alludes in its skeleton to that the difference between those two tests as being a reason why the finding about separability doesn't carry over.
I hadn't noted. I had thought. I mean, both the tribunal and Judge Auerbach didn't make that part of their reasoning. I perhaps hadn't read the skeleton carefully enough, but there isn't a respondent's notice saying they should have, is there?
No, my lord. And it may be that I am dealing with that out of an abundance of caution.
No, well, very wise thing to do. But okay, well, let's just come back to that. Thank you. That's been a helpful roadmap, and I'll keep quiet while you go through it. But you're right. The proposition I question is your second.
Yes.
Proposition.
Yes. And the reason I go with the first proposition first is because in my submission I acknowledge that I do have to establish that the conduct is the same or materially the same before I can go on to make the second proposition. And so, dealing with that first point, that the conduct in question by the claimant was the same or materially the same in both claims. In the detriment claim, the respondent or the tribunal described the conduct by the claimant that the respondent was relying on as being the professional awareness point. That's shorthand in paragraph 215E. Slightly more detail in paragraph 144, which I took the court to earlier, which says that it was the claimant questioning the professional awareness of the issue in practice direction. I keep saying practice direction. I mean protected disclosure, of course. In protected disclosure 4. I acknowledge that in my skeleton argument, I said that it might be said that in the detriment claim, the respondent relied only on the claimant's conduct in the meeting on the 22nd of October. But in fact, my primary submission would be that that's not correct. And in fact, the respondent was also relying on the claimant's email on the 23rd of October as being the reason or part of the reason for Miss Harding's detrimental conduct to the claimant. And I can illustrate that by two extracts from the tribunal judgment, both of which I've already taken, your ladyships and your lordship too, so I can do briefly. The first point is that Miss Harding objected to both the claimant's conduct in the meeting on the 22nd and the claimant's, what she said in her email on the 23rd, and that's your lordship and your ladyship's reference, paragraph 154, that's the email where she said, "You've upset me by calling into question my professional integrity." And then paragraph 158, she said, "You were in effect questioning my ability to do my job, and you've done so again in your email below." So she clearly objected to both. And the second point is the point that I alluded to earlier and said I'd come back to, which is that the detrimental conduct by Miss Harding included conduct that postdated the email on the 23rd, and therefore she objected to the email. Some of the detriment happened after the email, and therefore at least a part of Miss Harding's reason for her detrimental treatment was the email on the 23rd as well as the conduct on the 22nd. And if that's right, then that is precisely the same conduct as the tribunal found was the reason for dismissal, because it described it as being having questioned Miss Harding's professional integrity, professional awareness / integrity, both orally at the meeting on the 22nd and in the email on the 23rd. Now, one other point to note in relation to the submission that it's exactly the same conduct is that the respondent in its skeleton argument does not say, or at the very least doesn't explain how the appellant's conduct relied upon by the respondent as a reason for dismissal was any different from the conduct of the claimant that the respondent relied upon as being the reason for Miss Harding's detrimental treatment. So there's, I suppose to be fair, one might look at the way the respondent has formulated the wording and say, well, it's alluded to, but there's certainly nothing concrete, no detail given as to why the respondent says the claimant's conduct was different between these two events. So in my submission, the conduct relied upon by the respondent to explain the detriment and to explain the dismissal was identical. But even if that's not accepted, in the alternative, it's materially the same. And I say that for essentially 4 reasons. Firstly, the email on the 23rd doesn't add anything that wasn't already said in the 22nd of October meeting. I've already taken the court to the quotation from that email in paragraph 155. The key part being that where the claimant said, I was a bit uncomfortable when the legal team questioned why it's bank to bank, since it's a reflection of legal awareness. Now that is the part that Mr. Mohammed objected to, and that is no more than what was said in the meeting on the 22nd. So I slightly elided two of my reasons. The second reason was, of course, that Mr. Mohammed's objection to the email on the 23rd was the same as Ms. Harding's objection to the conduct on the 22nd. So that's another reason why the conduct is materially the same. The third reason is that the tribunal's assessment of that email on the 23rd in paragraph 155 was that it was conciliatory in tone and careful in the way that it explained why the claimant was raising the issue privately. Now that clearly suggests that the email doesn't add anything to the conduct on the 22nd. And then the final point that I would pray in aid is the extract from the dismissal letter, which I've already read from, in which it was said that the first item on the charge sheet, if I can put it that way, was that the conversation on the 22nd led to Ms. Harding having a strong view that you were questioning her professional integrity, and then it went on to say, followed with a subsequent email reinforcing this view. So the email didn't add anything to what had already been said on the 22nd, and therefore even if the conduct that the respondent was relying on as being the reason for dismissal was not identical to the conduct being relied upon as the reason for the detriment, it was materially the same. The final point on the conduct being the same is that paragraph 225, the reason I took your Lordship and your Ladyships to paragraph 225 in my survey of the judgment was to show that it didn't make any difference that Miss Harding alleged that the claimant had questioned her integrity rather than her awareness. Because Mr. Mohammed was aware that that wasn't right, and it would have made no difference to Miss Garrett Cox in any event. And therefore, there's not even a subjective difference between the knowledge and understanding of the claimant's conduct on the part of Mr. Mohammed and Miss Garrett Cox, and the knowledge and understanding of the conduct on the part of Miss Harding. So for all of those reasons, I say that the conduct being relied upon as the reason was either identical or materially the same between the detriment claim and the dismissal claim. Which then leads on to the second point, which is the one that more directly answers your Lordship's point, which is that separability in my submission is an objective question. And if I could turn for the first time to the authorities bundle, and in particular to the case of Martin and Devonshire's, which is at page 130 and tab 10 of the authorities bundle. It starts at page 130, but the particular part is paragraph 22 of your Lordship's judgment, which has been quoted fairly extensively in the skeletons from both parties.
Which page did you say, sorry?
It's page 142, my Lord. Of the
May I
authorities
just
bundle.
say, because we spend an awful lot of our time complaining about the way in which bundles of authorities have been put together, this one seems to be exemplary, so whoever did the work should be
I'm grateful, my
be
Lord.
praised. It actually has tabs, which they often don't. Things are reported and appear in the correct reports, and we seem to have the right cases and none of the wrong cases. So well done, somebody.
And they're in chronological order.
And they're in chronological order. Yes.
Young, so.
But it's a relief to hear you say that, my Lord. I'm grateful.
There's some backstory here. Anyway.
So, paragraph 22 of your Lordship's judgment in Martin and Devonshire's, and of course, no doubt the court will be very familiar with the facts, but in summary, it was a case, it's a victimisation case rather than a protected disclosure case. But the claimant was dismissed having made protected acts, but the conclusion of the tribunal was that it was not the protected act themselves that were the reason for dismissal, but separable features of her conduct in making them. And I'd just like to pull out four particular parts of paragraph 22 to support the submission that separability is an objective question. The first is just below the letter C in the paragraph, where your Lordship said that the question of whether the reason for the dismissal is properly treated as separable is a matter of common sense and common justice, which I say suggests an objective test. Secondly, at the end of that sentence, the question is whether it can properly be treated as separable. Again, I say that suggests an objective test. Thirdly, the Lordship said just below letter F that employees who bring complaints often do so in ways that are viewed objectively unreasonable. So again, suggesting that the process that's been going through is an objective one. And then finally, and in my submission clinchingly, the conclusion of that paragraph is that an employer who purports to object to ordinary unreasonable behaviour of that kind should be treated as objecting to the complaint itself. And then Your Lordship went on to say we'd expect tribunals to be slow to recognise a distinction except in clear cases. So the test in my submission is an objective one for the tribunal. The question is whether the employer is to be deemed to be objecting to the protected disclosure if the given reason is not properly, i.e. objectively separable from it.
Well, this is only a decision of the EAT, and it's at an early stage of the development of this particular case law. It may be that the learned judge didn't express himself quite accurately. Isn't the underlying question necessarily, because this is what the statute says, what was the reason for the dismissal? Which means looking at actually the mental processes of the decision maker or makers. And if that is so, there is no room for a rule of law deeming them to have intended something that they shouldn't have. Sorry, did so. Again, they're motivated by something which they in fact weren't. It may be that, although even if this is inaccurately, that this is not quite accurately expressed, what we're really concerned with here is common sense evidential points, which mean that in cases where someone has behaved, as I think, ordinarily unreasonably, it's going to take a lot of convincing for the tribunal to say that that isn't really objecting to the substance of the complaint. So I'm afraid, it must be annoying for you thinking you've got to be on the Constitution, that you shouldn't assume that I am bound by what I appear to have said.
Yes, my lord. I entirely take the point. I suppose I would respond in two ways. Firstly, there is, of course, unconscious as well as conscious motivation. And yes, therefore, the question of whether conduct is properly separable goes to the unconscious motivation as well as the conscious motivation. And the second point is, I entirely accept, of course, that there clearly is a very large subjective element to the test. Indeed, it's almost exclusively a subjective test, save for this part where one is considering whether in reality the reason is to be seen as something different from the protected disclosures or not. And perhaps I can flesh that out by giving an example. The question that's being answered is what was the reason for dismissal? And therefore the analysis of whether it's properly separable must be made based on the facts as known to or understood by the decision maker. And therefore to take one of the examples given by your Lordship's judgment in Martin, if the decision maker genuinely thought that the protected act or disclosure had been couched in racist abuse, even though in fact it wasn't, then one would have to assess, obviously, the question of separability based on the subjective facts as known by the decision maker. But that doesn't, in my submission, mean that there's no place for the objective question of whether the conduct that's being objected to is more than ordinary unreasonableness and therefore is to be treated as being inseparable from protected disclosures themselves.
I mean, your submission is exemplary clear, but on this particular point, I'm not quite clear exactly what you're saying. You did use, and I understand why, the word deeming, which I didn't actually use it, but I did use the word treated as, which is much the same thing. And that is still what you're saying. There's sort of in this very particular respect, it's appropriate that there should be, or it's appropriate, it is the law that there should be a deeming of something, which is not actually the case. Now, how is that right in principle? Well, what's the jurisprudential basis for that submission?
Well, in my submission, it is because the question that the tribunal, when faced with this issue, is dealing with is, of course, what was the reason for the dismissal. And it's not a question, and I apologise if I give the impression that it was, it's not a question of saying, of deeming the employer to have had a reason that he or she didn't actually have. It's a question of finding out what the reason was, including subconscious as well as conscious motivation.
Yes, of course it's that.
And if the reason given by the decision maker is, when looked at objectively, simply not properly separable from the disclosures themselves, then it is not straying outside the exercise of finding the reason for a tribunal to say, well, looked at in the round, we find that the reason given by the decision maker is the same as the protected disclosure.
I think you're treating the concept of separability. It is your submission as an objective, as a sort of separate rule of law, to which there's only one right answer, which you approach objectively. But in fact, however precisely I may have expressed myself here, I was deploying the concept of separability. If I wasn't, I should have been. As a way of getting to what the actual reasoning was. And I think the law may go down the wrong turning if we get out of, which isn't in the statute, we erect some sort of rule of separability. Yeah, all the statute says is you must look at what the principal reason was. And that means reason in terms of what the decision maker was thinking.
Yes, my lord.
Consciously or subconsciously. I'm sorry, I'm
well, I suppose I would say, in response to that, my lord, that one tool that tribunals can and should use to assess what the reason was is looking objectively at whether the reason given is so close to the protected disclosures as not to be properly separable. And I acknowledge what your lordship says, that it may be, that may be an evidential question rather than a rule of law, but there is in my submission still clearly a place for that that process and that tool when assessing what the reason was.
Just one moment.
But doesn't your submission have to be that tribunals are obliged to adopt that approach? And if they don't adopt it, they are in law?
Yes, my lady. And
sorry, I'm being rather slow. Sorry, you go on. Yes.
my lord, I'm grateful. The conclusion from that submission is that because the conduct being relied on by the respondent in both the detriment and the dismissal was the same by the claimant, and because I say there is at the very least an objective element to the test that has to be looked at, then in fact the tribunal was or ought to have been ineluctably drawn to the conclusion that if the same conduct was inseparable for the purposes of the detriment claim, then it was inseparable from the purposes of the dismissal claim. And just before I leave the first ground, I would make this submission that the second ground is a more general point, and I can see that in some ways that is a high hurdle for the appellant to get over. But in a case where the tribunal had already made a finding of fact that the same conduct was inseparable from the protected disclosures, then perhaps one doesn't need, or a route to agreeing with the appeal and allowing the appeal is perhaps less of, one doesn't need to go into the metaphysical considerations of objective and subjective with quite the same detail if one simply looks at the findings that the tribunal had made in relation to the detriment claim in the round, in common sense and common justice, as your lordship said in Martin. And my submission essentially is that was a finding that was inconsistent with the later conclusion in relation to the dismissal claim. I'm grateful for your lordship's indication earlier that the issue of the test between detriment and dismissal claims, so material influence versus sole and principal disclosure, principal reason, may not be alive.
Well, that's how I saw it. If really up to you. You can deal with it as out of abundance of caution, or you can see whether Mr. Siddle really develops it. I think at the moment he may have an uphill struggle, but I may have misunderstood.
Well, I think, my lord, what I may do is just in literally 30 seconds set out what my position is, and then if I need to, I can come back to it. Essentially, what the appellant says about that is that, of course, the tests are different, but that's addressing a completely different question. That's addressing the question of how much influence a protected disclosure has to have on the decision in question. It's not about how one characterises the reason given. And they're conceptually distinct, and it really doesn't make effect on it. So,
sorry, can I? My Lady Justice Simler asked you about paragraph 229, and can I just ask you to look at it again, please, Mr. Young, because I mean, hasn't the ET here asked itself directly whether or not the decision makers were influenced by the protected disclosures?
My lady, what I would say about paragraph 229 is that the tribunal did ask itself directly whether they were motivated by the protected disclosures, but it seems to have done so on the with the already decided view that the claimant's conduct was separable from the disclosures. Because what paragraph 229 seems to be doing is saying, well, we've already said in paragraph 226 that it was the claimant's conduct that was the reason for dismissal.
Yeah.
We're then going to go on to look in paragraph 229 as to whether the protected disclosures had an influence, but it was viewing those two things as being separate. So it had already effectively, it was proceeding on, I don't know if assumption is the right word to use, but it was proceeding on the basis that the protected disclosures and the claimant's conduct were separate factors without having gone through, in my submission, the analysis of whether that was correct, because whether they were properly separable.
But is that the right way of looking at it? Because just to follow up on what the questions my Lord's been putting to you, isn't the question always what was in the mind of the decision maker? And ET go on to say that none of them looked in any way at what had led up to the incident with Miss Harding or at the underlying issues.
Well, they weren't looking at the... So there's a finding in 229 that they weren't looking at the content of the disclosures or the underlying issues, but they were looking at the way the claimant made the protected disclosure. And if one combines that with the tribunal's finding on paragraph 215E, that it was an implicit part of protected disclosure 4 to call into question Miss Harding's competence, then to conclude that the decision makers were not influenced by the protected disclosures without going through the analysis as recommended in Martin and Devonshire's as to whether is the conduct more than ordinary unreasonableness or not, then that was rather to beg the question that needed to be answered, which is whether they were properly separable or not.
Okay. Thank you.
Thank you, my lady. So I will move on then, if I may, to the second ground of appeal. And my submission here is that even leaving aside the finding at paragraph 215E, it was not open to the Employment Tribunal to find that the claimant's conduct in questioning Miss Harding's professional awareness / integrity on the 22nd and 23rd was separable from her protected disclosures. I would also like, if I may, to develop this submission in 3 ways. Firstly, by looking at what the authorities say about how the tribunal should approach the question of separability. Then by very briefly having a look at some illustrations of the facts of cases where conduct has been found to be separable in the authorities bundle, to see how it plays out in practice, and then to look at the Employment Tribunal's findings about the claimant's conduct in this case. And I would then propose to finish by addressing briefly the relevance, if any, to this case of the Faceit case. I hope I'm pronouncing that correctly.
So I've often wondered does anyone know authoritatively how one pronounces it?
I think the one thing I can, my colleague in Chambers appeared in it, and he always called it Faceit. So for that reason, I've always called it Faceit. This was the sole contribution I had before the EAT as well.
I apologise for forgetting that.
That's all right.
So I
propose
to just address that very briefly, and then also the respondent's submissions about the test for perversity. So, starting with the guidance from the authorities on separability, there is a preliminary point, which is that the authorities in the authorities bundle, relied on by the parties in this case, contain authorities on a variety of statutory prohibition on retaliation. So there are victimisation cases, including Martin and Page. There are protected disclosure cases, including Evans and Panayiotou. There are trade union cases, Morris, Lyon and Bass Taverns. And there's a health and safety case in the form of Sinclair. But my submission is that the principles that underlie these decisions are the same, or at least very similar, as between these different types of case. And there's a general point that shows that, and then there's a specific point. The general point is that a number of the authorities, take Panayiotou for example, refer to the guidance given in Martin and Devonshire's, despite that coming from a different statutory regime. And then the specific point is actually from Martin and Devonshire's itself. And this is, again in paragraph 22, I did say we'd be coming back to paragraph 22, it's page 142 of the bundle, of the authorities bundle. And it's the part just below the letter E, where your Lordship quoted from the Lyon case, saying that conduct would be not protected by trade union activity when it was wholly unreasonable, extraneous or malicious acts. And what your Lordship said there was that what is essentially this distinction has been recognised in principle. And I would therefore submit that the principles that are set out in the various cases, notwithstanding the fact that they are from different statutory regimes, they are applicable, or at the very least, they are highly relevant to the question of separability within the protected disclosure jurisdiction.
Feeling that I said something similar in Morris, but maybe I've misremembered. Doesn't matter. Anyway, I have your submission and speak for myself. It's obviously right.
My Lord, you did, and I will come to that momentarily.
Okay. It's paragraph 21. Yeah. Okay. Sorry. Keep going.
I'm very grateful, my Lord. So, having made that preliminary point, I would go on to make the submission that whilst I accept, of course, that it's the tribunal's role to make findings of fact on separability, the authorities do give guidance to employment tribunals as to what principles they should apply when doing so. And I would extract three particular principles. The most important one being the part that I've already read from in Martin and Devonshire, paragraph 22, which is, sorry, I've gone away from the page, where your Lordship said that an employer who purports to object to ordinary unreasonable behaviour of that kind should be treated as objecting to the complaint itself. So that's the first point, that it has to be more than ordinary unreasonableness. The examples given by your Lordship in that case were threefold. Firstly, an employee who had couched their protected disclosure or protected act in racial abuse. Secondly, someone who had accompanied a protected act or disclosure with a threat of violence. And thirdly, someone who insisted on making their protected act or disclosure by way of ringing the managing director at 3 a.m. in the morning. Now, of course, I understand that that is not and was not intended to be a complete guide as to what conduct will be separable, but it is in my submission illustrative, and it's illustrative because all of those examples are clear examples that would fall on the other side of the line. And that is consistent, and this is the second point, that is consistent with what your Lordship said at the end of the bit that I've just read. We would expect tribunals to be slow to recognise the distinction between the complaint and the way it's made, save in clear cases. There is also a reference to that in the B Act case, which I can take your Ladyships and your Lordships to if it would assist, but there it was said that conduct will be separable when a distinction can clearly be made between the facts of disclosures and the manner in which they were made. So it does have to be clear. And then thirdly, and this is the Morris point that your Lordship made earlier, in the case of Morris, which is at tab 19 of the authorities bundle, and it's paragraph 19, just below the letter D, the Lordship is referring there to the case of Lyon and subsequently the Bass Taverns case, and in particular in relation to Mr. Justice Phillips in the Lyon case, you said that, your Lordship said that his reference to acts which are wholly unreasonable, extraneous or malicious seems to me to capture the flavour of the distinction. So again, I accept it's not a statute and it's not set in stone, but there is guidance in the authorities as to whether conduct will be properly separable or not. So,
but are you submitting that conduct doesn't fall into one of the descriptions used in the authorities, just to adopt your way of analysing it for a moment? It can't, as a matter of law, be properly separable. I mean,
well, I suppose what I am saying is that at the very least, a tribunal considering whether conduct is properly separable will have to consider whether it falls into that category, whether it's more than ordinary unreasonableness. My primary submission is that, as a matter of law, it would be a failure to apply the relevant principles correctly for a tribunal to find that conduct that was no more than ordinary unreasonableness was properly separable and hence was a different reason from the protected disclosures. But I would make the alternative submission if your Ladyships and your Lordship are not with me on that. In the alternative, I would say that it will be an error of law for the tribunal to conclude that conduct is properly separable without conducting that analysis.
okay, well, that's very clear. Thank you.
So the first point was the guidance.
Yeah.
The second point is just very briefly to look at some of the factual examples in the authorities and to foreshadow the submission. The submission is essentially that in all the cases in which conduct has been found to be properly separable, it is really not a grey area. It's not in the grey area at all. It's very clearly on the other side of the line from ordinary unreasonableness. So we've already looked at the Martin case. That was a case in which the mental illness of the claimant meant that she did not recognise that her allegations were false. She was likely to make future false allegations that she believed to be true, and that there was a risk of further disruptive and unmanageable conduct as a result of her illness. Evans and Bolton School is the protected disclosure case in which the claimant had obtained access to the respondent's computer system in an unauthorised manner. The tribunal used the word hacked, and he'd enlisted help from an ex-pupil in order to demonstrate that his protected disclosures were correct. The case of Panayotou was a protected disclosure case, and the conclusion of the tribunal there, and perhaps I should take the court to that, it's page 191 of the authorities bundle, which is tab 13. And in particular, it's paragraph 55, which is at page 191 of the bundle. The conclusion there as to the conduct that was found to be properly separable is that was that unless matters were handled as Mr. Panayiotou believed they should be, he would not rest until he'd altered that course of action. If he did not agree with the way that the disclosure was handled, he would simply complain about that as well. By the time of his dismissal, he was occupying huge amounts of management time and for medical reasons was no longer able to function. And then at the end of that paragraph, as the tribunal put it in what it describes as its key finding, Mr. Panayiotou had become completely unmanageable. And then the final example is the case of Azam and Ofqual, which your lordship in Morris endorsed as an example where the conduct was properly separable. And in that case, the reason for dismissal was the claimant's gross misconduct in disclosing in breach of contract confidential information and in thereby disregarding a clear instruction from her manager. Now, again, of course, I don't suggest that simply by looking at the facts of past authorities and past cases, you can have a foolproof system for saying when conduct will be separable and when it won't be. But I would make the submission that if one looks at the facts of these past cases, they are all examples of cases in which the conduct very clearly, as per the wording in Martin, Dervishes and Bayat, falls on the far side of the line, separating orderly unreasonableness from conduct that is sufficiently serious to be properly separable. There is on the other side of that equation the Bass Taverns case, in which the trade union official, the conduct in question was using disparaging words about the company and saying that if prospective trade union recruits got injured, it would be the trade union that fought for them and not the employer that was concerned firstly with profits. He admitted in that case that he'd gone over the top, but it was found to be nothing beyond the rhetoric and hyperbole which would be expected at a recruiting meeting for a trade union. Neither dishonesty nor bad faith are suggested, and therefore in that case the conduct was not outside the scope of the trade union protection. And again, I simply refer to that to illustrate the point that conduct that is not clearly on the far side of the line of ordinary unreasonableness will not be considered to be properly separable. So perhaps I should move on to the third point in relation to ground two, which is really the meat of the submission, which is the Employment Tribunal's findings in relation to the claimant's conduct. And I would start, if I may, by just referring your ladyships and your lordship to three particular findings of the tribunal, which are referred to in my skeleton argument. The first is in relation to the meeting on the 22nd of October, and that's the finding that we've already looked at. It's page 215E, but I haven't actually taken your ladyships and your lordship to this particular part of it. Page 298 of the core bundle, tab 20, paragraph 215E. Particular part of that paragraph that's relevant to the gravity of the claimant's conduct, gravity or otherwise of the claimant's conduct, is the bit where it says the making of PD4 by the claimant in and of itself entailed implicit questioning of Ms. Hardy's legal awareness because she had overseen the putting in place, and then we acknowledge it was not a necessary part of protected disclosure in law to add the words such as it's a matter of legal awareness, and then crucially, but we find in this case the claimant did not raise her concerns about Ms. Harding's legal awareness in an unreasonable way. So that is a finding, that's distinct from a finding that the claimant had a reasonable belief in the truth of her protected disclosure, which of course is a necessary part of the protected disclosure. It goes further than that. It's a finding that the claimant didn't raise her concerns about the legal awareness in an unreasonable way. So that's the first finding that I rely on. The second is the bit that I have already read from in paragraph 155. Just very quickly, the tribunal found that...
Sorry, just give me the page reference.
My apologies, my lord. It's page 281, at the very bottom of that page, paragraph 155. The tribunal characterised the claimant's crucial email on the 23rd of October as conciliatory in tone, and careful in the way that it explains why the claimant had felt it important to raise the bank-to-bank issue only privately with Ms. Harding. So again, this is a characterisation of the claimant's conduct that was relied upon as the reason for dismissal. And then the third finding is later on in the judgment, paragraph 235B, which is at page 304 of the core bundle. This is in the context of the ordinary unfair dismissal. And the tribunal said, about halfway down that paragraph, reasonable employer would at least have recognised the claimant was acting reasonably in raising PD3 and PD4, but then perhaps more to the point, a reasonable employer would also, in our judgment, have recognised the claimant was at least endeavouring to raise with Ms. Harding in what she considered to be a sensitive manner, a legal issue which she considered could cause Ms. Harding some embarrassment, although we accept that a reasonable employer could conclude that despite her efforts, the way she actually raised it was not sensitive. Again, in my submission, that's far from a finding of conduct that is more than ordinary unreasonableness. Now, in fairness, I should also draw the court's attention to paragraph 242C, which is a few pages on, page 307 of the core bundle. This is in the context of the respondent's arguments about contributory conduct. And the tribunal in paragraph 242C said that...
One moment, sorry.
Sorry, my lord.
Where are we going?
Page 307, my lord, of the core bundle, paragraph 242C.
Thank you, yeah.
So this is in the context of the respondent's arguments about contributory fault, and the tribunal, under the heading the incident with Ms. Harding, the tribunal said, although we recognise that the claimant on that occasion expressed herself robustly and inappropriately to Ms. Harding, both orally and in her subsequent email. So I accept that that is a finding made by the tribunal, but I would say two things in response to it. Firstly, it seems with respect to be frankly inconsistent with the tribunal's earlier findings. In particular, paragraph 215E and 155. Because in 215E, the tribunal had found the claimant did not raise her concerns about Ms. Harding's legal awareness in an unreasonable way. And it's a little bit hard to see how that sits with the finding that she expressed herself inappropriately. But secondly, and in any event, even conduct that is robust and inappropriate is not clearly beyond the line of ordinary unreasonableness as per Martin. So taken as a whole, I say that the tribunal's findings in relation to the claimant's conduct was of conduct that was at most ordinary unreasonableness. It may even be less than that. There is one final point about the tribunal's findings of the conduct, which is that the tribunal's conclusion on ordinary unfair dismissal was or rather is set out at 235, paragraph 235, page 304. And I'd already taken your ladyship's lordship to paragraph 235B, but in fact 235C is relevant as well, because this was the tribunal's conclusion on ordinary unfair dismissal, and the tribunal concluded that we find that properly appraised of the facts, no reasonable...
Apprised of the facts.
Sorry, properly apprised of the facts. Apologies, my lord.
No, that's what they wrote appraised. Sorry, I'm just being pedantic.
No reasonable employer would have dismissed the claimant for the incident with Ms. Harding. Now, it is in my submission extremely difficult to see how the claimant's conduct could be more than ordinary unreasonableness if no reasonable employer would have treated it as sufficient reason to dismiss.
Yeah.
Now, I appreciate
It all depends, doesn't it, on whether there is some test of law based on more than ordinary unreasonableness, which is an area we've looked at before. If the question is what really was motivating the employer, reasonably or unreasonably, that is a question which was very carefully and subtly considered by the employment tribunal, wasn't it?
Well, in my submission it wasn't, my lord, because the paragraph in which they did consider that in relation to the dismissal claim is 229, and for the reasons I've given, I say that that consideration skipped over a crucial step, because it said, well, we found the conduct was the reason. We've already found the conduct was the reason for dismissal. We're going to go back and we're going to set out our thinking about was the protected disclosure the reason for dismissal. We find it wasn't because they didn't look at the substance of the disclosure, but they didn't grapple at all in the dismissal context with the question of whether those things are separable, whether they're actually the same thing. And that's particularly striking given the earlier finding they'd made in the context of the detriment claim, that the conduct was inseparable. The final point I should just make very briefly about the ordinary unfair dismissal finding is to take the court to the Lion and St James Press Authority, which is which is tab 3 of the Bible. In fact, actually, it may be easier to go to Morris, because it's quoted by Your Lordship in the judgment in Morris, and that's tab 19, and it's page 310 of the authority's bundle.
Yes.
And Your Lordship, they're quoted from the Lion case, in which Mr. Justice Phillips said, the special protection afforded by paragraph 6.4 to trade union activities must not be allowed to operate as a cloak or an excuse for conduct which ordinarily would justify dismissal. And the point I make from that is simply that it suggests, at the very least, that where conduct would not ordinarily justify dismissal, as the tribunal found in this case, then it will not be properly separable.
Hang on 1 second.
Did Mr. Justice Phillips mean, when he used the phrase justified dismissal, result in a dismissal that was not unfair, or does he just mean, I don't know, it's a little bit different.
My lady, in my submission, he's talking about the reason for dismissal, but I can take you to the Lion case itself.
Right, so what he really means is conduct which is capable of justifying a dismissal. Anyway, doesn't matter. If you tell me that that's what he means, I'm happy to take it from you. So in other words, it's what he's talking about is conduct which falls within whichever subsection it is.
Yes.
The list of
And that's why the quote starts with the marks within which the decision must be made are clear. So it's a question of whether it's covered by the protection for trade union related activities. Just to summarise the appellant's position in ground 2, in the primary points, if I can put it that way, and I'll come on to a couple of points of perhaps preemptive rebuttal. The most that the appellant could be accused of in my submission is tactlessness, by expressly stating something that the employment tribunal, and indeed the appeal tribunal, found was implicit in her protected disclosure 4. In fact, when one looks at the facts of this case, in many ways, the appellant was an exemplary whistleblower. If one bears in mind the realities of life and of the workplace, and hence that perfection may not be attainable, she raised reasonable concerns in a reasonable manner and attempted, even if the tribunal found this not to have been wholly successful, to be sensitive to the feelings of the person whose work was inevitably implicitly being criticised by the disclosures. And hence I say that at the very most, her conduct amounted to ordinary unreasonableness, and the respondent ought to have been treated...
It didn't amount to ordinary unreasonableness.
Sorry, my
At
lady,
most.
It appeared, it amounted to at most, so no more than ordinary unreasonableness.
All right, okay.
There is a wider point about the consequences of this decision, I don't want to trespass on what may be said by the intervener, and I'll keep this very brief, but I'll simply to make the observation that if this is a sufficiently clear case to amount to conduct that is properly separable, then in my submission, almost any employee making a protected disclosure will be at risk of losing the protection in the Employment Rights Act for whistleblowers in relation to the automatic dismissal provisions. So those are my submissions on primary submissions on ground 2. I would just like to finish by dealing with a couple of points. Firstly, it's whether the Fessett case has anything relevant to say about this case, and then secondly, the point about the test for perversity. So dealing with the first of those, the respondent says that effectively Fessett has already decided this point and that ground 2 therefore must fail as a result. In my submission, that is not right, essentially for 2 reasons, although they are related. The first is that this case is, in my submission, in a different category to Fessett, because the current case was a dismissal. The reason for dismissal was the claimant's conduct in making the protected disclosures. Fessett, the dismissal was not for conduct, it was because of the breakdown in relationship between the parties. And it's of note that the respondent in the current case did advance an SOSR. I was going to say SOSR reason, but I realise that's saying R twice.
It was rejected by the...
But it was rejected by the by the tribunal. And to the extent that I may have suggested in my skeleton argument that Ms. Harding's upset was a reason for the dismissal, that was an impermissible finding. In fact, my primary submission would be that on the tribunal's findings, the fact that Ms. Harding was upset was not found to be the principal reason for dismissal. And in fact, it's clear from paragraphs, or from both paragraph 226, which sets out the reason for dismissal, and paragraph 227, where the tribunal said that it was dealing with a few other issues, and I quote, for completeness, and that's where it dealt with Ms. Harding's upset, that the tribunal was not finding that the fact that Ms. Harding was upset by the disclosures or by the claimant questioning her, that was not the principal reason for dismissal in this case. And as a result of that, it's my submission that different principles apply when one is considering a dismissal for conduct in the manner of making disclosures, or indeed any kind of conduct, compared to some other substantial reason being the breakdown of relationships. And the reason for that is that where conduct is the reason for dismissal, in my submission, the tribunal ought to consider and apply the ordinary unreasonableness approach to separability. But of course, that approach can't apply to an SOSR dismissal for breakdown in relationships, because there's no conduct on the part of the claimant to assess against the yardstick of ordinary unreasonableness.
I mean, it seems to me obviously seems to the tribunal SOSR isn't the right route in these cases. They analysed and focused, the tribunal analysed and focused on what she had actually done and what perhaps more accurately, on what the decision makers thought she had done that justified dismissal. And the fact that someone was upset as a result of it is not to the point.
Well, my Lord, I would entirely...
It's the conduct that causes the upset, which must be what the decision maker must look at, and the employment tribunal in assessing the decision maker's reasoning must look at.
Yes, my Lord, I would respectfully entirely agree with that, and but the consequence of that in my submission is that Fessett is simply not relevant to this case, because it was of note in Fessett that there was no criticism.
I think this is what is the problem, that I don't. You've been efficient enough up to now to justify us allowing you to do some preemptive rebuttal. But the problem is we haven't actually looked at Fessett. We haven't seen exactly how the point's being put. I think.
Well,
maybe the sensible thing is come back to it in
Certainly.
reply
Certainly.
if Mr. Siddle says something about it. But we're in a slightly halfway house here.
Certainly, my lord. I'm very happy to leave that point. And so in that case, the final thing that I will say is just very briefly about the test for perversity, because the respondent says in its skeleton argument that ground 2 is essentially a perversity appeal, and that the claimant can't get over that hurdle, and therefore ground 2 must fail. And I would start by saying that I certainly don't shy away from making the submission that the tribunal's conclusion was perverse, for reasons I've already given in my submission. The test from Yeboah and Crofton is met, and there is an overwhelming case that the Employment Tribunal reached a decision that no reasonable tribunal on a proper appreciation of the evidence in the law would have reached. But, notwithstanding that, I would respectfully introduce a slight note of caution as to the court's approach to the Yeboah test on the facts of this case, and that is for 2 reasons. The first is related to the case of Sinclair. And if I could take your ladyships and your lordship to that case, it's the final case in the authority bundle. It's tab 23. It's an EAT decision of Mr. Justice Chowdhury, President of the EAT, in relation to a health and safety detriment dismissal case. And one important point to note about this case in my submission is that it's the only authority in the authorities bundle that came to the appeal in a similar posture to, or rather, when looking at it now, is in a similar posture to the current case, in that the tribunal had found in that case that dismissal was fair for a reason that was properly separable from the health and safety activities, and the claimant appealed that decision in that case. It's clear from paragraph 15 of the judgment that that appeal was advanced on a perversity basis. Paragraph 15, page 392 of the authorities bundle said, in particular, it said that the tribunal's conclusion was perverse, given the findings of fact in the judgment. But nonetheless, it is of note in my submission that Mr. Justice Chowdhury's decision, particularly in paragraph 22, but throughout, doesn't cite Yeboah and doesn't refer to the guidance there on perversity appeals at all. And if I could take your ladyships and your lordship to paragraph 22 of the judgment, in particular, paragraph 22D on page 393 of the authorities bundle, what Mr. Justice Chowdhury said was that although the tribunal's findings as to the reason for dismissal are ones of fact, and therefore not readily disturbed by the appeal tribunal, this is one of those cases in which the tribunal can be said to have erred in law in reaching its conclusions as it relied upon a matter, namely the upset caused to the workforce, that was not properly separable from the carrying out of the activity itself. And the conclusion that the dismissal was other than for the carrying out of health and safety activities was not a permissible option. So the Employment Appeal Tribunal in Sinclair seems to have treated the decision about separability as being an error of law because the tribunal relied on matters that were not properly separable, notably without reference to the test in Yeboah. And that points in my submission to potentially a second factor, which is that the nature of the question on an appeal like this and in Sinclair is, in my submission, one of legal labelling or characterisation, not perhaps pure finding of fact. And therefore, an appeal tribunal or court is really at no disadvantage compared to the tribunal at first instance in carrying out that exercise, based, of course, on the tribunal's primary findings of fact. And what I take from that is that I make the submission that the overwhelming case required by Yeboah to overturn a finding of primary fact on perversity grounds may not be directly applicable, as per the approach of Mr. Justice Chowdhury and Sinclair, but I wouldn't want that to detract in any event from my primary submission, which is that even if that is not accepted, and even applying the Yeboah test directly with no caveats, the Employment Tribunal's decision here was perverse, because the test includes a proper appreciation of the law, and in my submission, that would have included the fact that only conduct that is more than ordinary unreasonableness could properly be treated as separate from the protected disclosures. And because the Employment Tribunal never directly addressed that question in relation to the dismissal claim, then had it done so, had it considered that, i.e. with a proper appreciation of the law in relation to separability, then for the reasons I've explained, no reasonable tribunal would have concluded that the claimant's conduct was separable from her protected disclosures. So, my Lord and my Ladies, for those reasons, in my submission, both ground 1 and ground 2, with respect, ought to be allowed, unless I can be of any further assistance to your Lordship or your Ladyships. Those are my submissions.
Unless my ladies have any question. No, thank you. Those have been extremely clear and economical submissions. Thank you.
Please, my lord, my ladies, can I first of all hand up the documents which didn't make it through to all members of the court?
Yes.
Just explain what they are. They are clean and track change versions of what we call the proposed structured approach in our submissions, and I'll come on to that in due course. Thank you very much indeed. Can I start my submissions by first of all thanking the court for giving Protect the opportunity to intervene in this appeal and make written and brief oral submissions. My oral submissions will be in 3 parts. First, very briefly, our understanding of the salient elements of the Employment Tribunal decision. That, of course, provides the framework for the submissions of principle which we are advancing. Second, a discussion of the law relating to what we call the Separability Principle. And third, to take the court through the proposed test, recognising, of course, that the court ultimately may decide that no test is necessary whatsoever. Before I embark upon part 1, can I just note that much of what Mr. Young says we adopt. I'll be clear, I hope, in my submissions where that isn't the case. He's also covered much of the ground that's in my speaking note as well. I will do my best not to duplicate what he has said, but please forgive me if from time to time there is a degree of duplication. As I said, I will attempt to avoid that. So let me start, if I may, with our understanding of the salient elements of the Employment Tribunal decision. The claimant made various protected disclosures. Protected disclosures 3 and 4 involved her, implicitly or explicitly, it doesn't really matter for current purposes, casting aspersions upon what the tribunal describes as the legal awareness of Ms. Harding. Ms. Harding was upset by that. Ms. Harding's reaction to Ms. Cole was hostile, and it would have been, on the tribunal's own findings, an unlawful detriment under section 47B, but for the limitation problem. That is what the tribunal finds at paragraph 215. It's impossible, of course, to read 215 without noticing a point which my learned friend Mr. Young has rightly emphasised, 215E, an express finding that the claimant's criticism of Ms. Harding was inseparable from protected disclosure 4. And for the avoidance of doubt, I completely endorse and adopt everything that Mr. Young said in relation to the objective aspect of assessing separability. I have nothing to add to what he said in relation to that. The tribunal found that the principal cause, and that phrase is the phrase used by the tribunal, principal cause of the dismissal was the incident on the 22nd to the 23rd of October. See paragraph 221. In particular, it found that the claimant's questioning of Miss Harding's legal awareness was the cause, or, and again I'm using the tribunal's language, the principal reason, paragraph 226. Where we slightly part company from Mr. Young is in the role of the upset. This may be a certain amount of semantics, but I understood Mr. Young to disavow the suggestion that Miss Harding's upset was a reason for the dismissal, the principal reason. Our reading of the tribunal judgment, and especially paragraphs 226 and 228, was that the tribunal saw the claimant as criticising Miss Harding and also causing Miss Harding upset, and that was what distinguished the claimant's behaviour on this occasion from previous occasions when she had criticised her colleagues. See paragraph 228. It is, of course, no part of our role to argue the appeal. I'm not proposing to take the court to it, but 228 is where the tribunal focused on the upset. It is, of course, important not to lose sight of paragraph 229. Again, we agree with what Mr. Young has said in relation to this. At 229, what the tribunal is doing is going back to the statutory definition of a protected disclosure, namely a communication of information which ticks various boxes, and asking whether the decision makers had that in mind at the time that they made the decision they did. I have to say, it's a bit difficult to square even the limited reasoning in section 200, in paragraph 229, with the earlier references to Mr. Mohammed's hostile reaction to being blind copied on the email from the claimant, which he criticised, and Mr. Young's referred to that. But even putting that to one side, all that the tribunal is dealing with at section 229, paragraph 229, is the substantive content of the information which comprise the protected disclosures, and no more.
Hang on 1 second. Is that right? Surely what they're dealing with is the making of a disclosure with that content.
Perhaps it might be helpful to take up paragraph 229. Two-thirds of that paragraph consists of...
Sorry, let me just reread it in the light of the submissions you're about to make. Yes, I see. Now, what's the submission you're about to make?
Well, I know that the court's already asked questions about paragraph 229. So the submission I was about to make in response to my Lord's question was that two-thirds of paragraph 229 is concerned with the respondent's subsequent reaction or treatment of the underlying issues raised by the claimant. In other words, what they're focused on at 229 is the substantive content of the protected disclosure. They're not looking at the manner in which it's made, the extent to which it necessarily, or accidentally for that matter, involves criticism of Miss Harding, or indeed Miss Harding's response to it.
Isn't this a false distinction? what the essential object of the legislation is to do is to prevent workers from being, at this point, dismissed for making protected disclosures. And that means a situation where the employer doesn't like a protected disclosure being made. So I'm stating rather obvious points, but you were trying to draw a distinction between content and the making.
Yeah, absolutely, I am.
But it's a meaningless distinction.
No, forgive me, maybe I haven't expressed my answer to that question particularly elegantly. We say there is a false distinction. The false distinction is the distinction between the substantive content of the protected disclosure and then matters which fall within the corona about it, around it, or...
Oh, I see, but that's, okay, but 229 doesn't really bear on that at all. What they are clearly saying is the decision makers had no problem with this disclosure being made. And that's, you can't distinguish there between the content of the disclosure and the making of the disclosure. It's the making of a disclosure with that content, if you like. They weren't bothered by that. Now, there's a separate question, and this is obviously what this case is about, but whether you can separate off other things connected with the making of the disclosure, which they were bothered about.
Exactly. It's in other words.
Sorry if
I completely agree with that analysis. The point I suppose I'm making, and forgive me if I'm doing this in a laborious way, is that paragraph 229 is not a get-out-of-jail-free card for the respondent in this case, because the tribunal is only looking at a very narrow aspect of the making of a protected disclosure. It doesn't address the matters which, as my lord, to use my lord's language, the things that the employer was bothered about.
Well, isn't it? Why isn't it a get-out-of-jail-free card? That's a pejorative way of putting it. Why isn't it the answer to the actual question in the case? Because by saying that, they are saying they weren't concerned about the thing which the legislation is aimed to protect. They were concerned with different things. And your point is, or the issue in this case, is whether the things they were concerned about can properly be treated as different.
Absolutely. That's the question. So it's simply saying we've considered whether or not that they were motivated by protected disclosures, and we've concluded that they were not, is not a get-out-of-jail-free card if the remainder of the employment tribunal judgment demonstrates that they excluded from their consideration matters at that stage, matters which they had expressly found contributed to the dismissal, and which, on Mr. Young's argument, are inseparable from the making of the protected disclosure. I absolutely agree with my lord's introduction of the phrase false distinction. The false distinction has been introduced by the tribunal. We say that actually the reason for dismissal in this case can be boiled down to a single sentence. The respondent dismissed the claimant because Miss Harding was upset that the claimant had criticised her in a protected disclosure.
Where do you get that?
I'm synthesising the paragraphs to which I've just referred. 215, 221, 226, 228.
Why is that the right analysis? Isn't the right analysis that the real reason that they dismissed was because she had behaved in a way which they genuinely believed was inappropriate and liable to cause upset, as it in fact had. It's not the upset, it's the conduct that caused the upset.
Again, with respect, I don't see a particular distinction. They're two sides of the same coin.
Well, I'm not sure. I think it's quite important. As Sinclair perhaps demonstrates, it's rather easy for an employer faced with a whistleblowing complaint, which, as perhaps most whistleblowing complaints do, will upset somebody.
Indeed.
To say, oh, they weren't worried about the complaint, they were worried about the upset. And that may well be a false distinction. But if there was something other than the making of the complaint, something about the way in which it was made, that was inappropriate, and factually did cause upset, but that's not the essence of the point, why isn't that a distinct reason, or capable of being a distinct reason?
For the same reasons as have been developed in a line of cases stretching back to Laing, because it's so closely associated with the making of the protected disclosure.
Well, all right, but okay, but that's fine. That, I'm sure, is what this appeal is about. But I think upset's a bit of a red herring, isn't it? I don't see any sign myself, but we'll obviously have to look at it again, that the tribunal put all the focus on the upset. They put the focus on the conduct, because that's where they thought the employer.
Well, I did refer to paragraph 228 a little earlier, and can I imagine the court's got it open in front of
You are slightly straying into really arguing the case,
yeah.
which Mr. Young has already done admirably, but we'll let you just say something about 228.
Yeah, it's just simple. It's a simple answer to my Lord's question, and please, I don't want to overstate our position in relation to this. We're not saying that the reason for dismissal is the upset per se. That's the principal reason, but we do say that paragraph 228 demonstrates that the upset that the criticism caused to Miss Harding was the distinguishing feature which led to the dismissal, because the tribunal goes out of its way to explain the difference between the decision to dismiss on this occasion, when the claimant criticised somebody, and its previous inaction, when the claimant had criticised people on previous occasions.
But isn't this an evidential analysis saying why it wasn't just the fact of questioning the legal awareness, but something more about the way in which it had been done? The upset shows that there was something about the way she had behaved, which was
on a number of occasions in this paragraph, the tribunal is focusing on Miss Harding's reaction rather than precisely what it was about the claimant's conduct that had prompted it. Can I take it from 7 lines down?
Can I just make one other point before I let you do that? This is more directed, isn't it, to the attribution point?
I agree, that's the context in which this, certainly at the end of the paragraph, that's what they are dealing with, the attribution point. Of course, that's not part of this appeal. But one can hardly avoid noticing the clear observations of the tribunal 7 lines down. What was different on this occasion was the fact that Miss Harding had been apparently so upset by this incident, as reflected in her discussing the matter with so many colleagues, raising it with the management team in a formal meeting, and her expressed difficulty in working further with the claimant thereafter, including her refusal to mediate. And plainly, that's also not relevant, I should say, for a strict analysis of the attribution point. I'm not going to say anything more about that. Plainly, it's a significant part of the tribunal's analysis.
It's not the principal reason for the dismissal. What they're saying, they introduce paragraph 228 by saying what led the responses to this claim for that reason on this occasion was not just the fact that, and then blah, blah, blah. So part of the reason was not the principal reason.
They've already said what the principal reason is. The principal reason is the incident with Miss Harding. So this is a substantial aspect of that principal reason. My lord, my ladies, I'm not proposing to say anything more about the tribunal decision. I was taken longer on that than I had anticipated.
No, okay. Well, why don't you move on to the law on separability?
But before I do, can I just explain if our summary of the tribunal decision is even half right, why this is important? It is commonplace, as I think my lord just mentioned a few minutes ago, that when a worker makes a protected disclosure, causes upset. It isn't, we say, stretching the truth to say that protected disclosures typically involve some criticism of other people. Mm. And it's a natural human reaction to be defensive, to resist the fact that one is being criticised. The prohibition on victimisation of whistleblowers involves, to a certain extent, people who are criticised by whistleblowers reining in their natural instincts, suppressing them. Not a straightforward thing to do. So it is commonplace when people blow the whistle, that they ruffle feathers, that they upset their colleagues. It is, we say, a characteristic of whistleblowing in the workplace. This judgment of the Employment Tribunal, as it has been endorsed by the Employment Appeal Tribunal, has the effect, we say, of seriously undermining the protection available to whistleblowers. If it is legitimate for an employment tribunal to say, in respect of a whistleblower, you were not dismissed because you blew the whistle, but because in the way that you blew the whistle, you criticised somebody and they got upset by it, that is properly regarded as something separate from the protected disclosure itself. The effective protection confirmed by the Public Interest Disclosure Act will be severely reduced. We do not consider that this is an alarmist position, it is common sense. There will be few cases when an employer will not then be able to dismiss a whistleblowing employee with impunity simply on the basis that the employee has ruffled his or her colleague's feathers. And of course, there is a linked point to that. If that is truly the position, it will have a chilling effect on whistleblowing. Because employees and potential whistleblowing workers will understand that they can blow the whistle and the employer can say, yes, well, thanks very much for blowing the whistle, but because you've upset a colleague, we can't have that anymore. You're out. There have been lots of authorities since the introduction of the Public Interest Disclosure Act in 1998 which have discussed the supervening policy considerations that lay behind this groundbreaking piece of legislation. We've referred to many of those in our skeleton argument. Can I take the court to just one? And that's the case of Beard and Croydon. This was a surgeon who was dismissed after blowing the whistle. I think my Lord Justice Underhill was in Beard. My Lord was in most of these cases, in fact. I'm afraid that despite the praise that's being lavished on the bundle, my electronic copy doesn't have tabs, so I don't know which.
Tab 17.
It's tab 17. Thank you very much, Mr. Siddle. Can I go within Beard to page 278, paragraph 80? The point at issue in Beard was whether an employer could avoid liability for what would otherwise have been a 103A dismissal by saying, I didn't think they were blowing the whistle. I didn't appreciate it was a protected disclosure. And that argument was given short shrift, as one can see from my Lord's judgment at paragraph 80. But can I pick it up, please, at next at letter F, referring to the argument that was being advanced on behalf of the employer by Miss McNeill, Queen's Counsel. Such a state of affairs would not only be very odd in itself, but would be unacceptable in policy terms. It would enormously reduce the scope of the protection afforded by these provisions if liability under section 103A could only arise where the employer itself believed that the disclosures for which the claimant was being dismissed were protected. In many or most cases, the employer will not turn his mind to the question whether the disclosure is protected at all. Even where he does, most often he will be convinced, human nature being what it is, that one or more circumstances are present that mean that the disclosure is unprotected. I needn't read any further. So this court has had regard to the overall policy considerations, the danger of reaching conclusions which drastically reduce the effectiveness of the Act, and, importantly in my submission, given the context of this case, human nature. Can I now turn to the law and separability? And my submissions on this are going to be considerably shorter than I think they were going to be, given the comprehensive journey that has been taken by Mr. Young. First, we agree that all of the separability cases in the bundle, covering a wide range of different statutory torts, all have something in common. What they have in common is an inquiry into the employer's reaction to something that the claimant has said or done. They are, we suggest, conceptually identical, whether one's talking about victimisation under the Equality Act or the separate species of victimisation that exist under the Trade Union Labour Relations Consolidation Act 92 and various statutory torts arising under the Employment Rights Act 1996. If that is correct, then the parameters of what we've called the separability principle ought to be the same for it. In other words, there ought to be consistency in approach. I hope that what I'm saying is not contentious, because Mr. Young's already made the effective point.
Well, if time is short, as you say, this is a point Mr. Young's already made. He's referred us to cases where we've said it. So I'll move on. I doubt this is somewhere where you should be concentrating your fire.
The appellate cases on whistleblowing, they've been listed, identified. Bolton, Paniotto, Shinwari is also in the bundle. I'm not taking the court to any of those. But all of those cases do not involve full analysis of the principles underlying separability. They're cases determined on their facts. And we have to turn to the Equality Act cases and the other species of non-whistleblowing statutory employment victimisation cases to get an analysis of the principles. Like Mr. Young, I'd like to start, though, with Martin and Devonshire and paragraph 22, and in particular, the line which my Lord, maybe on reflection, was less comfortable with at paragraph 22. It's page 142 of the bundle. In my submission, the line, an employer who purports to object to ordinary unreasonable behaviour of that kind should be treated as objecting to the complaint itself, is absolutely correct. It does not involve any infelicitous language. The scheme just doesn't work. Can I develop
The scheme doesn't work unless it were right.
Exactly. The protection offered by the scheme. This is particularly evident in the context of whistleblowing cases. There is a highly technical regime which operates to establish whether or not a given communication of information is or is not a protected disclosure. If the question of whether or not detriment or dismissal claim succeed depended only on considering whether the employer had an objection to that particular communication of information, and nothing which might be very closely associated with it, be it the manner of making the communication, the upset caused by the communication, then for the reasons I've just outlined, the effective protection would be reduced to naught. And this is what lies at the heart of what we call the separability principle. It is a practical recognition that when one comes to consider the reason, the crucial question that underpins Section 47B detriment cases and 103A dismissal cases, when one comes to consider the reason, one is not just looking at, in the context of protected disclosures, whether the employer has an objection to the particular transmission of information. One is looking also at matters around that. Matters which are so closely associated with the making of the protected disclosure that common sense and justice demand that they be considered as one and the same.
These quite detailed technical provisions, if Parliament had wanted to put in a deeming provision to deal with that point, it could have done.
It didn't need to, because Parliament was aware from before or prior to the introduction of the Public Interest Disclosure Act in 1998 that equivalent provisions prohibiting dismissal, for example, on the grounds of trade union activities for health and safety reasons, had been approached in the way that Mr. Young's explained, you can see in the cases of Lyon and Bass and so on, and hadn't caused difficulty in practice. In other words, the law already recognised that one didn't take a narrow approach to the conduct or speech of the claimant when considering the reason for dismissal or the reason for detriment. And that's how the separability principle works. We say that's why it's justified. If my law's incorrect at paragraph 22, then the effective protection is, as I say, reduced to nil. And with respect to my own friend Mr. Young, we don't agree that the answer to this lies in the possibility of there being subconscious bias. That may be an answer in some cases, but it's not a cure-all, because there will be plenty of cases where the employer has no objection at all to the substantive communication, the protected disclosure, simpliciter, but has every objection to the upset that it causes, to the fact that relations in the workplace become frostier as a result. And we say, because that's a particularly commonplace consequence of blowing the whistle, but it's unthinkable that Parliament would permit an employer to dismiss with impunity in that situation. It's particularly obvious in this case, where you have essentially a blameless claimant, what Mr. Young described as an exemplary whistleblower. I have nothing to add to the way that Mr. Young developed his submissions as to the separability principle and its narrow ambit, by which I mean the limited range of circumstances in which it will apply. And the language that my Lord focused on in the Morris case, drawing on Mr. Justice Phillips back in Lyon, speaks for itself. What we say the effect of the various decisions across these different statutory regimes is as follows. And we say this is common to all victimisation claims, should be common to all victimisation claims. Where the reason for the treatment is unrelated to the protected disclosure or the protected act or the trade union activities and so on, then separability is established and the treatment will be lawful. That's proposition A. Proposition B. Where the reason for the treatment is related to the protected disclosure, protected act, trade union activities, etc., then separability will only be established if the worker's conduct amounts to identifiable serious misconduct.
Say it again, please.
When
it is related, then
separability will only be established if the worker's conduct amounts to identifiable serious misconduct. Can I illustrate those each by reference to a case?
You can. I mean, you were given 30 minutes, which you've now already had. I'm speaking to myself. We won't hold you to the essence of that, but I think you're going to have to be succinct.
Absolutely. I'm just simply giving an example of two cases that fall into each category. So one case that falls into each category. Where the reason for treatment, the first proposition, example of a case knocked out at that stage is Page. The reason for the treatment in Page, nothing to do with him performing a protected act, and everything to do with the fact that he avowed publicly he would adhere to his obligations. An example of a case in the second category is Bolton and Evans, where hacking into the IT system was part and parcel of making a protected disclosure, plainly related, but was obviously misconduct and so separable on that ground. And the test that we've handed up, I'm not proposing to go through it, the suggested test attempts to reflect those observations. What this case demonstrates is that tribunals still can get it wrong. And there's a long line of cases going all the way back to Laing, where the appellate courts have overturned decisions of the tribunal in relation to what I'm broadly going to call separability. We respectfully suggest this would be helpful and welcome to introduce perhaps more coherence and more coherence into the whole sphere of victimisation than currently is apparent. This isn't a straitjacket; it's a guide, and there will, of course, still be difficult cases. We accept that proposition. There'll still be difficult cases, but as Mr. Young says, the line shouldn't be drawn as narrowly as it is in relation to this case, because this is a classic example of an ordinary whistleblower essentially being victimised, we would say, without remedy, as things stand, for an ordinary feature of whistleblowing in the workplace.
Your point 4 on your handout doesn't say, if the answer to question 3 is yes, did the conduct constitute, sorry, again, the second sentence of it doesn't say, if so, the conduct will, as a matter of law, not be properly separable. You say, sorry,
Likely.
Is likely.
Yeah, can I explain?
But that's important because one then needs to know what is the ultimate criteria in which one is applying, to which this gives non-binding guidance.
Well, that reflects the line of authority. Again, this isn't just an attempt to synthesise the language that emerges from Laing and then through Morris. What's really being talked about there is serious misconduct, taking something out of ordinary unreasonable behaviour. That's already a question that tribunals have to grapple with. There may be a limit to what guidance can satisfactorily achieve.
No, but we've got to know what the ultimate question is. The ultimate question according to the statute, is what is the principal reason for the dismissal, and the starting point for that, which we at this level certainly can't go behind, is the reason is what was motivating the decision taker. So how does this guidance really take matters any further than where we are already?
I thought that might be the court's response. What it does, first of all, is it recognises that there are actually two aspects of separability.
No, I see that. No, that is quite useful. I see it.
I'm not sure I can say much more than that. And when that's the first point. It establishes the two separate aspects of separability. In relation to the first aspect, what we've tried to do is to formulate a way of explaining when it will prima facie be appropriate to link surrounding behaviour to the making of the protected disclosure. In other words, is it a feature of the making of the protected disclosure, a corollary of it, for example, in this case, the follow-up email on the 23rd of October, or a consequence of it, the upset caused by felt by Miss Harding? That's not a definitive answer, because if it is related in one of those three ways, then one goes on to establish to ask the question at 4: is it serious misconduct, or such other formulation as the court might think is more appropriate or better reflects the tenor of the authorities. My lord, I'm not sure I can say much more than that.
No, well, unless you want to argue strenuously for more time,
I'm not,
and unless my ladies have any further questions for you, that's been helpful and is probably the limit of what you can usefully say.
well, far from arguing for more time, I apologise for taking as much time as I did, and I broke for
Very good. No, thank you very much, Mr. Andy. Yes, Mr. Siddle.
My lord and my ladies, putting the respondent to this appeal's position as succinctly as I can, which I'm not often renowned for, I simply say this. This appeal does not disclose an error of law at all. What the court is faced with, in my respectful submission, is, notwithstanding superficial attraction, which might initially be felt to exist as regards some of the points deployed, particularly, I say this with no disrespect to my learned friend Mr. Laddie, but particularly as regard the points displayed by my learned friend Mr. Young, what one sees is a conspicuously careful and meticulously reasoned judgment of an employment tribunal, which was particularly alive to its statutory obligation to determine what motivated the relevant decision makers to make the decisions that they did. And I'll look, if I may, briefly at the different tests in due course. And came to an entirely defensible conclusion, reasoned with great care, and as regards which, in our submission, there is not only no warrant, we would respectfully go further and say there is no basis for this court to intervene. And I would briefly pick up on a point made by my learned friend Mr. Laddie in terms of the perceived chilling effect of this judgment on whistleblowers. It is very plain that this tribunal was not terribly well disposed to those whom I represented below and represent today. It is clear that this tribunal was not, if I could put it this way, desperate to accept the separability argument. Indeed, in virtually every other respect, significant criticism was levelled against those who instruct me. But what the tribunal did, if I might respectfully borrow the observations of Judge Auerbach below, was properly consider the law, look at the facts through a detailed prism, and come to an entirely sustainable conclusion. And so for all of those reasons, I say no error of law is sensibly disclosed. And for all of those reasons, I respectfully submit there's no basis for the court to intervene. That, as your lordship will appreciate, is my headline point. What I then propose to do, in terms of a structure of my submissions, in addressing the various points which have been advanced, is my structure effectively is to mirror that which is set out in my skeleton argument. So, firstly, my lords and ladies, I seek to look at the legal position deriving from the relevant statutory language, which I'll take briefly, and the tests that were needed to be applied by the tribunal as regards the various claims it was called upon to adjudicate. My next stage will be to engage in a close analysis of the tribunal's reasons and why, in my respectful submission, the submissions of my learned friends fall into the error of not reading the tribunal judgment as a whole, because in my submission, as has been demonstrated in a number of the authorities, it's important to read the judgment as a holistic whole. Having undertaken that exercise, I then propose to respond very briefly to the grounds of appeal, and then finally I'll pick up on the structured decision making which is advocated by my learned friend Mr. Laddie on behalf of Protect. So, dealing with the first of the points, can I, as it were, proceed to the wellhead and invite the court's attention to section 43B of the 47B, I apologise, of the Employment Rights Act. The court will find that at tab 24 of the authorities bundle, page 395.
Yep.
My lord and my ladies, this is the statutory provision that deals with subjection to detriment. And as the court will be aware, it was amended as a result of the Fessett decision, which we will come to in due course, to allow for liability for the actions of a worker being subjected to detriment by a co-worker. If one looks at section 47B1A, we see a worker has the right not to be subjected to any detriment by any act or deliberate failure to act done by another worker of W's employer in the course of that other worker's employment, or by an agent of W's employer with the employer's authority on the ground that W has made a protected disclosure.
Is that? Yes. This actually is a printout off the web. That's not actually how it must be lineated in the Queen's Printers Requirement. On the ground, that applies to both A and B.
It does, and indeed, as I was reading that, I thought, where's on the ground that's going to appear? So I share your lordship's observation. But on the ground, that applies to both elements of section 47B1A. And on the ground, that has been interpreted in Fessett, which we will look at, but not in this particular context, to mean materially influenced by. Now, the starting observation is that what section 47B is doing is looking at the mind of the worker who has subjected the co-worker to detriment. And by the operation of section 47B1B, vicarious liability applies, and that was the amendment which the decision in Fessett brought about, because that was not seen in the original form of section 47B. My lord and my ladies, if we then move to tab 25, please, one sees section 103A, which is the automatically unfair dismissal provision of the Employment Rights Act. And forgive me for trite observations. Classically, in an unfair dismissal, the employer needs to demonstrate a potentially fair reason, and then reasonableness is addressed at a second stage under section 98.4. In an automatically unfair dismissal case, the criterion of reasonableness doesn't matter. And if we look at section 103A, its wording is, an employee who is dismissed shall be regarded for the purposes of this part as unfairly dismissed if the reason, or if more than one, the principal reason for the dismissal is that the employee made a protected disclosure. So here, the statutory language looks to the employer and why it is that the employer has acted. And it asks a binary question. Is the reason for the dismissal that the employee has made a protected disclosure, or by extension, not? Now, the next stage of the analysis is to look at whom the employer is for the purposes of section, or whose reason is treated to be the reason of the employer under section 103A. And in my submission, the easiest route to look at that is the judgment in Bayet, which is tab 17 of the authorities bundle, from the judgment of my Lord Justice Underhill. And if I could take the court to paragraph 30, please, which is at page 265. A judgment with which Lord Justice King and the then Master of the Rolls agreed. At the foot of 265, what tends to be treated as the classic expression of the approach to identifying the reason for the dismissal of an employee for the purposes of section 98 and its various predecessors is the statement of Lord Justice Cairns in Abernethy, that a reason for the dismissal of an employee is a set of facts known to the employer, or it may be the beliefs held by him which cause him to dismiss the employee. As I observed in Manchester College and Hazel, Lord Justice Cairns' precise wording was directed to the particular issue before the court, and it may not be perfectly apt in every case. But the essential point is that the reason for a dismissal connotes the factor or factors operating on the mind of the decision maker which cause them to take the decision, or it is sometimes put, what motivates them to do so. See also cooperative and bad faith. So the effect of that, in my respectful submission, is that it's accepted that when considering the dismissal decision, the focus of the tribunal in determining what that reason is to look into the minds of the deputed decision makers. Now, there was a gloss placed on that in Jutty, which happily we don't need to address in my respectful submission for the purposes of this appeal. So, my starting observation is that when looking at the detriment claim, which involved a detriment being, or the claimant facing a detriment as a result of the actions of a co-worker, what the tribunal was required to do was look into the mind of Jenny Harding and see what motivated her. When dealing with the automatically unfair dismissal complaint, by way of contrast, the tribunal had to look into the minds of the relevant decision makers, who were Mr. Mohammed and Mrs. Garrett Cox. There was also the gloss of the involvement of Alison Yates, and we'll look at the tribunal's findings in that regard in a moment. But in both cases, or as regards both causes of action, the tribunal was required to ask itself a binary question. And the binary question was this: as regards the detriment claim, was the detriment done on the ground of a protected disclosure? As regards the automatically unfair dismissal claim, was the sole or principal reason for the dismissal the protected disclosure or not? And I respectfully emphasise a point made in mine and my learned friend Mr. Anderson's skeleton argument, that what the separability ground involves, and I realise I'm jumping ahead slightly, is an answer to a binary question. What the court is not engaged, or the court or tribunal is not engaged in, is a metaphysical jurisprudential exercise of seeking to, forgive me for putting it this way, splice the reason of the employer. What it is doing is asking itself a very simple question. What motivated them? And was that motivation either because or not because of a protected disclosure?
Quite ambitious to say that's a very simple question.
My lord, yes.
On the contrary, it's a very difficult question.
It is.
In many cases. But I take your point. It is a very specific question.
Yes. If I might adopt and slightly amend your lordship's observation, it's a question that's deceptively easy to state.
But you accept not always simple to answer.
But not always simple to answer.
That's a better way of putting it. Yeah, thank you.
But what I do say is, its answer is a question of fact.
Okay, well, I see the time.
My lord, yes.
We'll rise now, and we will sit again at 2 o'clock.
So did your lordship say 2 o'clock?
I did say 2 o'clock.
Thank you.
Yes,
I'm
I hope I did.